Ghapoo Yadav vs State of Madhya Pradesh. A detailed analysis. Ramlal is the father of the victim and is also the prosecution witness number 1. Ramlal has 2 sons. Lekram, who is the prosecution witness number 2, and Gopal, the deceased victim. Ghapoo Yadav is the main accused. The other accused persons are his sons, Janku, Keval, Mangal, and his nephew, Sundar. The background of the case. Mangal Singh's land was occupied by Ramlal, who had a berry tree on it. Although Ramlal initially owned the tree, he relinquished possession after the measurement of the land was completed. However, Ramlal's family cut down the tree a day before the actual incident. On 9th June 1986, a dispute erupted between the accused persons and the family of the deceased Gopal, including his brother Lekram and his father Ramlal, over the cutting of the berry tree. The accused assaulted the deceased, fracturing his leg. Ramlal and Lekram fled but later returned with other villagers. The villagers took the injured victim to the police station, where he reported the incident, and Dr. R.K. Chaturvedi found 7 injuries on him. The deceased took his last breath on 10th June 1986 at 2 a.m. His dying declaration was recorded. The trial court found the accused guilty and convicted them under sections 148 and 302 read along with section 149 of the Indian Penal Code. Reliance was placed on the evidence of the 2 eyewitnesses as well as on the dying declaration. The conviction and sentences imposed were upheld by the High Court. The accused appealed to the Supreme Court.
The defense argued that the injuries sustained by the deceased were in course of a sudden quarrel, without any premeditation and without any cruel intention. Therefore, Section 302 IPC was not applicable. Section 302 IPC cannot be applied even if the prosecution case is accepted in toto, and Exception 4 to Section 300 of the Indian Penal Code is clearly applicable.
The Supreme Court held that to apply Exception 4 of Section 300 IPC, which covers homicides committed in a sudden fight, certain conditions must be met. Firstly, the act must occur without premeditation, in the heat of passion, and upon a sudden quarrel. Secondly, the offender must not have taken undue advantage or acted in a cruel or unusual manner. Thirdly, the fight must involve mutual provocation, not just unilateral provocation. Hence, to apply Exception 4, it's not enough to show only a sudden quarrel and lack of premeditation. It must also be shown that the offender did not exploit an unfair advantage or act in a cruel or unusual way. Of the 7 injuries, only injury number 2 was grievous and could have caused death. The injuries and their nature indicate the accused's intention, but they were not inflicted in a cruel or unusual manner. After the injuries were inflicted, the victim fell down, but there is no evidence that further harm was inflicted while he was helpless. The Supreme Court finally held that in the heat of passion upon a sudden quarrel followed by a fight, the accused persons had caused injuries on the deceased, but had not acted in a cruel or unusual manner. Exception 4 to Section 300 IPC is clearly applicable. The fact situation bears great similarity to that in the case of Sukhbir Singh vs State of Haryana. Appellants are to be convicted under Section 304 Part I, IPC, and custodial sentence of 10 years and fine as was imposed by the trial court.
Thanks for watching.